Hi, my name is Olivia and I'm a legal director in the employment team at Birketts, specialising in acting for clients in the financial services sector. Thank you for joining us today. This is the first in a series of short videos aimed at individuals working in HR, compliance or with people responsibilities in businesses that are regulated by the FCA. In these videos we'll be looking at some of the issues affecting the sector, and today we'll be focusing on what non-financial misconduct is and what the regulators are proposing to change. So the historic position in relation to misconduct in financial services was that misconduct was always assumed to be conduct that related to a firm's financial services activities, so for example protecting consumers. Indeed, when the conduct rules were originally drafted and put into place, the examples provided by the FCA all appeared to relate to the firm's financial activities arising from the conduct of someone's performance in their role. It was 2018 when we started to see a shift in the FCA's attitude and a widening of the scope of the definition of misconduct, and this culminated in a series of speeches and Dear CEO letters where it was made clear that non-financial misconduct is misconduct, plain and simple. Further statements made clear that harassment and discrimination could also count as non-financial misconduct, but beyond these statements, the industry has received very little guidance as to when a finding of discrimination or harassment might be classed as regulatory misconduct, what sanctions should be appropriate in the circumstances, and what information should be included on a regulatory reference. So much has been left up to the discretion of each firm, depending on their own internal culture, and many have been asking for clearer guidance to help them. In addition to the conduct rules, firms and the regulator have to satisfy themselves that an individual remains fit and proper, and this has typically involved a wider consideration of somebody's standing in the community. The FCA has already brought several fit and proper cases against individuals for non-financial misconduct, including for things such as sexual assault. However, the majority of these cases have involved a criminal conviction, so these are plainly at the more serious end of the spectrum. The High Court has also looked at the extent to which a regulator can take into account matters in an individual's personal life when deciding whether to ban them. It's not always clear cut. Most examples, though, do not reach this level of seriousness, and firms have been left with limited guidance as to in relation to conduct that, while serious, is not at the extreme end and where there's no criminal conviction or even a report has been made to the police. In the past, firms have set their own standards and cultural expectations, and they've provided training and developed policies to support their approach. We've also looked to borrow guidance from other regulators, so including the Solicitors Regulatory Authority and the Teaching Regulation Agency, which consider similar concepts and case law. So now, in an effort to put non-financial misconduct on a much clearer footing, the FCA launched a consultation paper last year, and it invited views from interested parties. Alongside this paper, they produced their set of draft rules. So this suggests that whilst the final position has yet to be confirmed, it's unlikely that the FCA is going to change them significantly. The FCA are of the view that these proposals clarify their existing expectations. The consultation paper proposes that the conduct rules, which apply to most employees in financial services firms, are amended to include express reference to non-financial misconduct. So it's clear that the rules cover serious instances of bullying, harassment or other similar behaviour. Secondly, the FCA is also going to amend its guidance to the fit and proper test for employees and senior personnel to explain that bullying and similar misconduct within the workplace is now relevant to fitness and propriety, and that similar serious behaviour in a person's private life is also relevant. Thirdly, the FCA will amend its guidance to the suitability criteria for firms to operate in the financial sector to include offences such as sexually or racially motivated offences and court findings that a firm or an associated person such as a director has committed discrimination. The new rules do introduce new concepts that are difficult to grapple with. In particular, what is considered morally reprehensible to one person won't be to another. Some discrimination is unintentional and unintended, and clearly this must be treated differently to more overt cases of discrimination and harassment. At the end of the day, some of these concepts are difficult to interpret, and ultimately only a tribunal or court can determine whether someone has discriminated against another person. Many of our clients are starting to look at providing training to the workforce on their firm's expectations around behaviour, And we're recommending that those regulated by the FCA start to build in more examples that highlight the professional consequences of engaging in non-financial misconduct, such as bullying, harassment and discrimination.